Hi, everyone, and welcome to another episode of Legal Tings. Today, we're talking about negotiating a settlement in a business dispute. If you're running a business and encounter a dispute with a business partner or some other stakeholder, negotiating a settlement for the dispute can be a better option sometimes compared to litigation in court for several reasons. Number one, the cost. Litigation can be expensive with legal fees, court fees, and other expenses adding up quickly, whereas negotiating a settlement can be faster and more cost effective to resolve a dispute. Number two, the time. Litigation can take a long time, with cases and proceedings often taking months or even years to conclude. But negotiating a settlement can often be concluded in a matter of weeks or months, allowing the parties to move on from the dispute more quickly. Number three, predictability of the outcome and the control you have. In litigation, the outcome is determined by a judge and the court and can be difficult to predict. However, in a settlement negotiation, you and the other party have more control over the outcome to select and shape the terms of the settlement and mutually acceptable agreement that work best for both sides. Number four, the issue of confidentiality. Litigation is a public process, with the sensitive, embarrassing, and damaging details sometimes of the case being made available to the public. On the other hand, negotiating a settlement allows the parties to keep the details of the dispute completely confidential and limit the reputational damage that can be caused with an ongoing court claim. If you're thinking of how to negotiate a settlement, here are some steps you can consider taking to give yourself a better opportunity of reaching an agreement to resolve the dispute. Number one, identify the key issues at stake. Clearly identify your goals, objective, and what you hope to achieve through the settlement, as well as the key issues that need to be resolved in the dispute, and then rank them in order of importance. Number two, prepare, meaning gather as much information as possible about the dispute, including all regular. It's okay, just carry on. Number two, prepare, meaning gather as much information as possible about the dispute, including all relevant documents and evidence related to the dispute, such as contracts, invoices, and correspondence. Number three, consider your negotiating position, including what you are willing to compromise on and what you are not, meaning identifying what your best case scenarios and targets are and what your bottom line position is. Number four, communicate openly and honestly with the other party and brainstorm a variety of possible solutions as you explore potential options, with both sides making the effort to try to understand each other's perspective and concerns whilst weighing up the pros and cons of each option and being prepared to make compromises and concessions where necessary. Number five, document the final mutually agreed terms. After you've reached a mutually acceptable agreement, remember to record the terms and conditions clearly in a separate agreement that's signed by both parties. Remember, the key to a successful settlement negotiation often is to approach the process with a cooperative and collaborative mindset, focusing on finding a solution that works for both parties and having a willingness to compromise. By working together, the parties can often find a mutually acceptable solution to their dispute, avoiding the cost and uncertainty of litigation. So, now you know. If you've enjoyed listening to this and would like to hear more, subscribe wherever you like to listen to podcasts and follow me on TikTok and Instagram. And remember, it's not rocket science. It's just legal things.